In the world of business, all employees have a contract of employment, which is a legal agreement between the employer and the employee that sets out the terms and conditions of the job. This contract serves as the foundation of the working relationship, ensuring both parties understand their rights and responsibilities. Under British law, an employer is required to provide a written contract of employment to an employee within 2 months of starting work. However, it is common for many businesses to provide this contract at the outset of employment, ensuring clarity from the beginning. A contract of employment must include several key pieces of information. First and foremost, it should state the names of the employer and employee, along with the job title or a description of the work to be done. It must also outline the start date of the employment, and whether the job is permanent, temporary, or fixed term. The contract should clearly state the employee's working hours, which can vary depending on whether the role is full-time or part-time. Full-time employees typically work between 35 and 40 hours a week, while part-time employees work fewer hours, often on a flexible schedule. For example, a part-time shop assistant might work 3 days a week, compared to a full-time assistant who works 5 days. Part-time roles are becoming increasingly common, offering employees greater flexibility to balance work with personal commitments such as studying or family responsibilities. In some cases, a business may offer a job share, where one full-time position is shared between 2 people. Each employee in a job share works part of the week, with the total hours adding up to a full-time position. For example, 2 office workers might each work 2.5 days a week, sharing the responsibilities of one full-time job. Job sharing can benefit both employees and employers, as it allows individuals to work fewer hours while still maintaining the advantages of a permanent position, such as holiday entitlement and pension contributions. For the employer, it provides flexibility and ensures that work is covered throughout the week. A contract of employment must also specify the employee's pay and how often they will be paid, such as weekly or monthly. In addition, it should outline any additional benefits, such as bonuses, pensions, or healthcare. The contract will also include details on holiday entitlement, which in the UK must be a minimum of 28 days a year for full-time employees, including public holidays. Sick pay arrangements and notice periods for ending the contract must also be covered. For some employees, especially those in industries such as retail or hospitality, a 0-hour contract may be offered. 0-hour contracts allow for a great deal of flexibility, as they do not guarantee a set number of working hours. Instead, the employer offers work as and when it is available, and the employee can choose whether or not to accept it. This type of contract is often used for roles where demand fluctuates, such as waiting staff in a restaurant or delivery drivers. While 0-hour contracts can provide flexibility for both the employer and employee, they have been criticised for offering less job security, as employees may not know how many hours they will work each week. However, for some individuals, particularly students or those seeking a second job, 0-hour contracts can be an ideal way to work around other commitments. In conclusion, contracts of employment are essential for defining the relationship between an employer and an employee. They must be provided within 2 months of starting work and include important details such as job duties, hours, pay and benefits. Employment can be structured in various ways, from full-time and part-time work to job sharing and 0-hour contracts, allowing businesses and employees to find arrangements that suit their needs. Each type of contract offers its own benefits and challenges, making it vital for businesses to carefully consider the best options for their workforce.